Bismillahirrahmanirrahim. Indeed, it's a great honor for me to be here amongst Pakistanis, Americans, and the luminaries from all over the world. I'm grateful to the Open Forum for providing me this opportunity. As there is a time constraint, that what I have decided that I have framed 4, 5, 6 questions, and I would be dealing with those questions in order to just give the overview of the cooperation between the judiciary and entrepreneurship in the Pakistan for those who are within or outside of Pakistan. The first question which I have framed, and this relates to how does the Pakistani legal code facilitate entrepreneurs. According to me, freedom of the trade, business or profession has been recognized by Article 18 of the Constitution of the Islamic Republic of Pakistan, which says that every citizen shall, subject to law, have the right to enter upon any lawful profession or occupation and to conduct any lawful trade or business. In addition, different laws such as the Companies Ordinance 1984, the Securities and Exchange Commission of Pakistan 1997, the Mudarba Ordinance 1980, and the Partnership Act 1932, besides other legislation for conducted lawful trade and business are in the field. I may explain here that as far as the citizen is concerned, its definition also includes who are the foreigners in the term of Article 5 of the Constitution. Thus, under the Constitution, both who are the citizens by birth living in Pakistan or who have for the time being shifted there for the purpose of their business or for making investment, they are also to be treated under Article 18 of the Constitution and equal opportunity. I would be explaining that how the equal opportunities are available to them after a while, but at this stage only I would be pointing out that they enjoy equal protection, facilities and opportunity for the purpose of running the business in Pakistan. And there is no difference between the entrepreneurs who are the Pakistani, local or the foreign promoters. They can establish their business over there in terms of the provisions of Companies Ordinance 1984, and these concern may be profitable, non-profitable, and some of the main concerns are as under. I have just given the list. I will try to read them. A private company limited by the shares with minimum one member director can be established as per rules from under the SRO of 203 of December 2nd. This concern operates in Pakistan by the name and the style of single member company private limited, SMC, which may be called ABCD, XYZ, whatever the name may be. And number 2 is the private company is the one which is limited by shares with minimum 2 or more member directors with or without having shareholding of any local or the foreign entity therein. If the shareholding of the local or the foreign entity is more than 50%, then it shall be termed as subsidiary of that local or the foreign entity holding company. This company operates by the name and the style of ABC, and you have seen that there is no distinction between the local or the foreign company. This can be registered under the Companies Ordinance 1984 more than if there are the 7% for the purpose of the registration. Next is the public companies limited by shares of the 2 types, listed and non-listed. Listed companies are registered with the stock exchanges in Pakistan, and their shareholders are traded in the capital market. Minimum number of the members of the directors in a listed corporate concern is 7, and in case of non-listed public companies, the minimum number of the membership of the directors are 3. This is again another facility which our laws provide to the businessman who intends to set up a business in Pakistan. So these companies operate by the name and style of whatever they consider, but it would be known as a limited company. And number 3rd is there is another type of the public concern which may be a profitable or non-profitable, such as companies limited by guarantee are of 2 types. It may operate with a share capital or without having share capital. The one having the share capital can be termed as a company limited by guarantee with share capital profitable, and the other one will be a non-profitable concern as it will operate without having share capital. This company is incorporated under section 43 of the Companies Ordinance, and it operates by the name of the style of the as a guaranteed limited company. Another non-profitable public company, which basically is an association incorporated with single object under section 42 of the ordinance before the registration with the concerned company's registration office. Its promoters are required to obtain license from the Securities and Exchange Commission of Pakistan. For the purpose of the tax exemption, this association or the company is registered with the relevant tax authorities, and basing upon the case to case as far as the exemption is concerned, exemption is also granted to such company from the payment of the tax. This is another incentive which our government is providing under the law. Currently, for the purpose of the establish a branch office of the foreign company in Pakistan, this is very important. I would emphasize that we should consider it very seriously. First requirement is to register it with the Board of Investment and thereafter with the SCCP. Branch office of a foreign company operates in Pakistan in similar fashion as if it is operating in its country of origin. This is a very great incentive for the purpose who are the companies from outside the country to run the business over there without any restriction, considering it as if it is running its own origin country. Basically, SCPC is the main facilitator of these corporate concerns, and at the same time it regulates their affairs under the Securities and Exchange Commission of Pakistan Act 1997 and the Companies Ordinance 1984. There are a number of other organizations which are playing the role of watchdog on certain relevant sectors, companies such as the Stock Exchange, Competition, Commission of Pakistan, the State Bank of Pakistan, Oil and Gas Regulatory Authority, the Mudarba. Companies are governed and regulated under the Mudarba Ordinance 1980. Pakistani courts facilitate the entrepreneurs for providing adequate remedies as per the law. Under Section 7 of the Companies Ordinance, the original jurisdiction of the company matter vests with the High Court of the competent jurisdiction. In order to exercise this jurisdiction under Section 8 of the Ordinance, each High Court in Pakistan has one or the more company benches which are constituted by the Chief Justice of the concerned High Court's company. Judge is specifically assigned with the job of adjudicating upon the company matter. This may be considered that the highest forum in the High Court, a judge has been allocated for the purpose of dealing with the affairs of the company. There should not be any doubt in such like cases when the matter is before the High Court. Of course, the same is required to be disposed of expeditiously. There is a time limit which has been framed, which has been provided. According to that framework of the limit time, it is to be decided either way. Apart from the above, profitable concern in the shape of the partnership is registered under the Partnership Act 1932. It is registered with the registrar of the firms with the minimum 2 partners. Partners are bound under the deed of the partnership executed between them. This is another part. This is another type of the running the business in Pakistan under the Partnership Act. Both company and the partnership concern are the legal entities, and one main difference between the two is that in case of the company, the liability of the directors is limited, meaning thereby that they are liable only to the extent of their shareholding in the paid-up capital of the company, and in partnership, the liability of the partner is personal. As regards the sole partnership concern, it is nowhere registered under any law in Pakistan, although it is not a legal entity and or it has no legal footing. However, its irregularities are entertained by the courts in Pakistan only on the basis of that it has a bank account and the national tax number. There are certain other laws such as the Societies Registration Act 1861, the Voluntary Social Welfare Agency Registration and the Control Ordinance 1961, the Trust Act 1882 and Endowment Act 1890, where under non-profitable entities are also registered, and the courts at all levels in the Pakistan facilitate in case of any mishandling of the matter therein. And the courts are handling all these issues in a highly befitting manner according to the law and taking into consideration facts of the case. And the second question which I would like to point out and explain is with regard to, is the Pakistani legal courts catching up the technology? What are some of the initiatives within the legal community and some key decisions in the recent past in this regard? Because I am of the opinion that as far as the Pakistani legal courts are concerned, they must be equipped with the latest technology for the purpose of handling of the cases, because then it would be the beneficial for the person who are running the business over there. Recent advancement has enhanced the role of the information technology in every walk of the life, and the judiciary is also getting benefits of this important tool for enhancing its efficiency. For automation of the justice sector, a comprehensive plan has been chalked under Access to Justice program to address the following areas, facilitating main stakeholders like the judiciary, the litigants, and the lawyers. And those are case flow management system, case institution, case fixation, cause list generation, case of tracking, public inquiry desks, inspection of the lower courts, complaints against the lower judiciary, library management system, research and the reference systems, archiving of the case documents, budget and accounts. And National Judicial Automation Committee has been constituted to ensure that as far as all the courts starting from the district judge up to the high court, they had a uniform sort of system where there should not be any difficulty for the litigants as well as for the lawyers in order to approach to the court and for the redressal of their grievances. What is this NJAC? NJAC is to achieve the objective of the said plan, the National Judicial Automation Committee was constituted by the NJPMC in 2009. I may explain too that there is a statute mean ordinance, which is known as National Judicial Policy Making Committee Ordinance. Under that, the powers have been given to the Chief Justice of the Supreme Court and all other Chief Justices in order to make the improvement for the purpose of betterment of the system and as well as for the interest of the litigants. Under said provision of the law, this NJAC was formed in 2009. Nevertheless, some of the proposed plans are functional at the Supreme Court and the High Court. Present status of the automation, Supreme Court of Pakistan. Supreme Court of Pakistan has its own independent software with a different feature which is precisely prescribed. Number 1, case fixation and generating cause lists, advocate adjournments alert system, information counter for facilitating the advocates and the litigants, generates different reports regarding status of the cases, weekly and the monthly disposals, bench and disposal, etc. Library of the management system, online case status, online cause list of the principal seat and all the branch registries, online case law management and system, online electronic case messaging system, software for the human rights and HRC management. Similar sort of systems have been evolved in the high courts of the Sindh, Punjab, as well as Quetta, and in the district judiciary. Those all systems are performing very well for the purpose of the interest of the judiciary as well as the litigant. And I believe that by the passage of the time, as far as this aspect is concerned, it will be further improved for the purpose of bringing it at par with the other system throughout in the country. Next question is important with regard to what are some of the mechanisms that are in place for updating the legal code, and what are some of the points of cooperation with the judiciary and the parliament. This is again important because unless there is no cooperation between the judiciary and the parliament in respect of the updating the code of the law is concerned, it won't be possible. The constitutional scheme of Pakistan envisions a trichotomy of the powers, which means that there is a separation of the powers between the three organs of the state, namely the executive, the legislature, and the judiciary. As far as the legal code of Pakistan is concerned, the supreme law of the country is the constitution. All other laws enacted by the parliament are subordinate to the constitution and must conform to the constitution. All new laws and amendments to existing laws are enacted by the parliament. The parliament of the Pakistan is a bicameral legislature, is that it consists of a directly elected lower house called the National Assembly and an indirectly elected upper house called the Senate. All bills are passed by the simple majority of the members of each house and assented by the President of Pakistan. However, the constitution is amended by 2/3 majority of each house. The President of Pakistan, on advice of the Prime Minister, also has the power to make or amend the laws in fast-track process, which cuts through the delay.
I think we should move to the questions. You want to take a seat?
Yes, that may occur through parliamentary enactment. As far as the remaining portion or the question is concerned, I will be answering after when the questions are put to me through you people. Thank you.
The grounds of challenge are very limited. If the foreign procedure was perverse, if there was no substantive due process according to a recognized standard, yes, that would be challengeable. And I can give you an example.
We have got the laws on the subject, and if there is any violation of the intellectual property, then strict action is taken. And as concerned, who had chosen to go and make the investment in the software, fully protected under those laws.
I will make a concession to say that yes, there is a disparity between the letter of the law and the actual ground reality. You would see that in China also. There is an issue of intellectual piracy in a number of jurisdictions. But I do notice that increasingly intellectual property rights are being understood as being valuable property rights. Pakistan is now proactive in its defense of intellectual property rights.
Governments more business friendly than civil governments in Pakistan.
You exclude that when I take the, I think it's something.
Well, if we start with the hypothesis that business thrives where there is the rule of law, the entire notion of contract law is based on a particular set of rules, on a particular exchange of promises. So it's a myth to say that because there is an authoritarian regime, it will cut through the red tape and investment will be more secure. But I think history teaches us this lesson, that absent the rule of law, after all, a contract, the enforcement of a contract involves issues of the rule of law. So I don't subscribe to the view that you can say that certain kinds of crony capitalism do thrive in an authoritarian regime. But to say that the overall development of a country under an authoritarian regime is something to look forward to, I disagree.
So, Chief Justice, we've gotten a couple of questions on some of your decisions, including the Pakistan steel mills decision and decisions about privatization. And I'd like to have you explain, what the facts were and what your ruling was, because I think not everybody here.
There was a petition, rather two petitions, under Article 184, Sub-Article 3 of the Constitution, which deals in respect of the enforcement of fundamental rights. And as far as the fundamental rights are concerned, those are available to all the citizens of Pakistan under the Constitution equally. The complaint was that as far as the privatization of the steel mill is concerned, it is not being carried out in a transparent manner, and the assets are being sold to the near and dear or the cronies of the regime. Therefore, the public at large are bound to suffer on account of selling or privatizing this steel mills at a throwaway price. Government of the time duly contested this petition, and a bench of 9 members, 9 honorable judges, including the Chief Justice, conducted hearing of the case for months together, and ultimately concluded that as far as this deal is concerned, it is not a transparent and suffers from so many omission and commission and violation of the law of the Privatization Act. Therefore, on having taken into consideration and to ensure the enforcement of fundamental rights of the general public, because all such assets belongs to them. As far as the deal was concerned, it was declared so. Subsequent thereto, government came into appeal and review petition, and that review has also been dismissed, mainly or mostly for the same reason. So I believe that by making interference, the laws on the subject and the precedents within Pakistan and outside of Pakistan in respect of such like deals were relied, and this interference was made, because there is always scope as far as the constitutional provision is concerned. Constitution does give the jurisdiction to the court in order to examine such type of deals in order to save the country from the loot and the plundering. So this was the main reason.
If the steel mills is one example, then we see on the anvil the upcoming privatization of PIA, of the telephone sector, of the railway sector, of so many other sectors. I would venture to state that if the steel mill deal smells, then you're not going to be able to privatize
because the privatization process itself will smell. If it lacks confidence, then the privatization is a non-starter. So the statistic that you've taken about foreign private investment declining, I think that has no relevance whatsoever with the steel mills case. And the steel mills case, it was a local group which was taking over the steel mills at throwaway prices. There was absolutely no correlation. Yes.
So that wasn't a foreign investment?
No. Yes, there was a case of the mining rights in Balochistan, the recording case, which judgment was also authored by the former Chief Justice. But there, $1 trillion worth of mineral resources, $1 trillion, were being sold away for a paltry sum of $100 million. The court is bound to step into this route of national assets.
Okay, thank you. That was a very compelling answer.